Toolkit for Mental Health Professionals. Ethical Dilemmas with Legal Implications by Marimak and Zalak Parmar. Number 1. Flowchart for navigating legal decision points for duty to warn and protect. Let's start. Has the client communicated a threat? If not, maintain confidentiality, document the session. If yes, see is the threat specific and directed to an identifiable individual. If not, continue monitoring, consider further assessment and document rationale. If yes, see is there a clear and imminent danger of harm. If not, assess further, document thoroughly and consult supervision if unsure. If yes, do you state laws mandate or permit breach of confidentiality? If it permits, use clinical judgment, consider protective actions and document rationale. If it mandates, proceed to warn, protect, notify victim and or the law enforcement. If no duty is defined, seek legal consultation, follow ethical guidelines and document thoroughly. Has the supervision or legal consultation been sought? If not, consult immediately before acting. If yes, take protective actions like notify intended victims, contact law enforcement, consider hospitalization or other interventions, document every step taken and the rationale behind it. How to use the flowchart. Start from the top and thoroughly check each decision steps. Assess the threat. Has the client's threat been specific and directed towards an identifiable individual? Check the state laws. Refer to your jurisdiction's legal requirements. Consult when needed. Always seek supervision or legal guidance in unclear situations. Document thoroughly. Record all assessments, decisions, and actions taken. Use this flowchart for training purposes. For teaching, use this as a teaching tool for staff or students. Keep it updated as the laws and guidelines evolve. Review and revise the flowchart. Lastly, but not least, maintain client privacy unless disclosure is clearly justified. Number 2. Informed consent, duty to warn. In the informed consent, it explains the limits of confidentiality to the client. It clarifies when the therapist must break confidentiality, for example, of threats, abuse, and legal orders. This includes clients' and therapist signatures, and it protects both therapist and client by ensuring informed consent agreement. In this informed consent, it includes confidentiality in therapy, legal exceptions to confidentiality, duty to warn and protect, documentation and records, client's rights and questions. It must include the signatures of both client and the therapist with the date. Number 3. The reference guide table with relevant statutes and precedents. The well-known landmark case of Tarasov vs. Regents established duty to warn, protect if a client poses a threat to an identifiable victim. In Jablonski vs. US, the clinicians must review prior records. Failure to do so can result in negligence. Ewing vs. Goldstein stated extended duty to threats communicated by the third parties, for example, the family members. California Civil Code Section 4392 states psychotherapists must act if serious threat is communicated to them. Arizona law states privileged communication may be broken if client poses danger. Texas law states no affirmative duty to warn only permissive disclosure. How to use the reference table. Refer the table when assessing whether to breach confidentiality in a forensic or a clinical setting. Use it as a quick guide during supervision, legal consultation, or risk assessment. Always check the local and state laws, as statutes may change or vary in scope. Number 4. The frequently asked questions. There are multiple questions we come across. There are 5 questions which are asked most. What's the difference between confidentiality and privilege? Can I share a threat made by a client without their permission? What if the threatening information comes from someone other than the client? What tools can help evaluate how dangerous a threat is? Should I seek advice from supervisors or legal experts? Let's see. The difference between confidentiality and privilege. Confidentiality is a professional responsibility to keep clients' information private, while privilege is a legal protection that allows you to refuse the sharing certain information in a court of law. Can I share a threat made by a client without their permission? Yes, if your state's law require it, or if the threat is serious, credible, and pose an immediate risk to someone's safety, you are allowed and sometimes required to disclose it. What if the threatening information comes from someone other than the client? In some states, such as California, following the Ewing case, the duty to warn or protect can extend to threats reported by third parties, not just direct client disclosures. What tools can help evaluate how dangerous a threat is? Structured assessment instruments like Violence Risk Appraisal Guide or the Historical Clinical Risk Management 20, used alongside your professional judgment, can help determine the level of risk. Should I seek advice from supervisor or legal experts? Absolutely. Consulting with supervisors or legal counsel is important to ensure how to handle the situation ethically and legally. So be sure to document any consultation as a part of your clinical records. Let's see an extended guidebook to duty to warn and confidentiality. In this PDF, we can see a quick guide to decision tree flowchart, a template for documentation, quick reference guide table with case laws and laws, case study with an example, frequently asked questions, and a link to American Psychological Association. Let's check the references. These are the references that you can go through to understand it better and further extend the understanding of how to stay on track and legally and ethically in check. These are the toolkits that you can use and help yourself to guide yourself on a journey where you are requiring help, clarity, and guidance on what to do when you come across an ethical dilemma. Follow the toolkit and keep yourself in check. Thank you.